And thank you all for joining today's panel discussion on prosecutors, Brady, and police disclosure lists. My name is Michelle Mason, and I'm a Policy and Operations Associate at the Institute for Innovation and Prosecution. Today's panel complements the IIP's Action Guide for Tracking Police Misconduct, which launched last month and is available on the IIP's website, prosecution.org. I'd like to take this time to read a land acknowledgement statement which honors both the land and culture of Indigenous peoples. We want to acknowledge that the IIP and John Jay College are based in New York City, which is Lenape-Hoking, Lenape homeland. We honor all of the Indigenous nations and their land with great gratitude and acknowledge the genocide and continuous displacement of Indigenous peoples. We also acknowledge the enslaved Africans whose labor built Manhattan during the colonial era and beyond. We acknowledge the harm inflicted upon the Indigenous communities and people of color across the country, which inspires our ongoing work. And with that, I will turn it over to Alyssa Mark-Hayderi, the Deputy Director of the IIP, who will be moderating the panel today.
Thank you so much, Michelle. Thank you everybody for being here, and good afternoon. We at the IIP have received so many inquiries over the years from prosecutors, academics, and journalists asking about these lists of police officers that some prosecutors' offices have to track police misconduct. Over the years, we've learned that many prosecutors' offices, they don't have a list or a formal policy on how to track police misconduct. And the lack of this kind of database means that line prosecutors, they may not be aware of prior misconduct of officers on their cases, so they can't accurately assess their cases, and critically, they may fail to comply with their legal and ethical obligations. So that is why the IIP, early in July, we released a new action guide called Tracking Police Misconduct, and it was based on many interviews that the IIP did, as long as, in addition to collecting written policies of these prosecutors' offices. And the hope is that prosecutors can use this guide to create their own databases or improve upon the ones that they may already have in place. So to discuss this topic and some of the IIP's recommendations, we have three very accomplished panelists joining us. We're very lucky to have this group of experts and who are being so generous with their time. So I'm going to introduce them. They have very long biographies that are on our website, so I'm going to read a shortened version of them. Chief Harold Medina is currently serving the Albuquerque Police Department as Chief of Police. He started his police career in November of 1995 with the Albuquerque PD, and he retired in 2014. But he was not done, because he then became Chief of Police for the Pueblo of Laguna. In December of 2017, Mr. Medina was appointed to Deputy Chief for the Albuquerque Police Department. In September of 2020, he was upgraded to Interim Chief of Police. And in March of this year, Mr. Medina was appointed as Chief of Police for the Albuquerque Police Department. So Chief Medina, thank you so much for being here with us today. Ross Miller is the Assistant Director of the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Carey School of Law. The Quattrone Center is a nonpartisan national research and policy hub producing and disseminating research designed to prevent errors in the criminal justice system. Prior to his work at the Quattrone Center, Ross was a criminal defense and civil rights attorney practicing in federal and state courts. And last but not least, Raul Torres was sworn in as Bernalillo County District Attorney on January 1st, 2017. Born and raised in Albuquerque, Raul Torres is a former federal prosecutor and was a senior advisor in President Obama's Department of Justice. He worked for nearly a decade as an assistant United States attorney, assistant attorney general, and assistant district attorney. And so Raul Torres has worked at every level of the criminal justice system, protect our community, and fight for justice. So thank you again, all three of you, for being with us here today. DA Torres, we'll start with you. Your office implemented a Giglio policy. If you could sort of tell us, what is your policy and how does it track police misconduct?
Well, first, I want to thank you for giving me the opportunity to talk more about the implementation of our Brady disclosures. It's something, as you've mentioned, that our office has been looking at and sort of puzzling, how we can implement what I think is, frankly, one of the most important police accountability measures today. But I also want to just take this opportunity to thank also Harold Medina, who has very much been an important partner and without whom we probably wouldn't have a successful program. My own interest in this, frankly, started when I was at the U.S. Attorney's Office here in Albuquerque, and we had a very standard but somewhat limited approach to understanding what kind of integrity issues may be subject to disclosure, how those issues were tracked, and then ultimately shared with our counterparts in the defense bar. And so, one of the things that we settled on, frankly, during the opportunity that was presented during COVID when we all went remote, is whether or not we could build the infrastructure to start doing and tracking police integrity inquiries and disclosures online and in a comprehensive way. And so fundamentally what we have done is implemented a policy where on every single felony referral into the district attorney's office, we ask the referring officer to complete a series of questions, about 7 or 8 questions, depending on the agency, relating to findings of misconduct in their history about the preservation of evidence, use of force, even things that touch on their social media use. We then disclose the answers to those questionnaires to defense counsel in real time, at the same time that we receive those answers. And then we follow that up with an agency letter, which was standard practice at the U.S. Attorney's Office, but only in those instances where we had some basis for making an inquiry at the outset. So the most important element is that we do this in every single case, and we do it as a 2-step process that involves both an officer questionnaire and an agency letter. And then ultimately it goes to an internal panel, the Brady Giglio panel inside my office. They review the information, and if they decide that there is a sufficient basis to make a disclosure, we then make that disclosure to opposing counsel, and we also file a notice with the court so that there's a pleading that accompanies the disclosure in the court file. And then last, and probably most controversially, we take that information on officers where a disclosure has been made, and we make it publicly available. We actually publish the names of the officers along with a link to the pleadings on our website, so that there is never a moment where we have information in our possession that would necessitate a Brady disclosure, and those are somehow hidden from public view. That, I think, is probably the most sort of innovative step, if you want, in terms of prosecutorial practice, is making that information available. I know that offices around the country either maintain lists that they're not publicly distributed, or there's been a lot of litigation about whether or not that information should be made public. It was my judgment and frankly my belief that if we were going to move our system to provide enhanced accountability and transparency, and fundamentally prevent the possibility that officers with integrity issues would simply move from one agency to the next, that was information that the public should have available to it. And so, like I said, we didn't just implement the policy unilaterally. We then engaged with both Chief Medina and his leadership team, but also with the union representatives here in the Albuquerque Police Department, and went through a series of negotiations over the nature of the questions, how they would be handled, how the information would be disseminated, and finally came up with what I believe to be one of the most comprehensive policies in the country. And we are still in the early stages. The next phase is to implement and deploy an automated tool so that we're not asking these questions case by case with our own ADAs and officers. The officers will submit cases online in a paperless system, and as part of the filing of a case or submission of a case into our office, they'll fill out an automated tool and we'll be able to capture the information. So we're definitely, I think, in new territory with the policy and with the program, but so far I think it's working very well.
Thank you. So in the chat for the audience, I put in a link to the appendix that the IIP produced along with the guide. And if you click on Bernalillo questionnaire, it has a copy of the questionnaire that DA Torres's line prosecutors is having the police officers fill out. And then I also dropped the link, DA Torres, I think this is the right one, where it has a description of your policy on your website. And at the end is sort of the list of officers who you've made disclosures about. Question for you, Chief Medina, is, my understanding is you were in the Albuquerque Police Department relatively high up when this policy was introduced. So what was your reaction to the policy? And if there was apprehension or concern among the police officers in your department, how did you sort of communicate the change and respond to their concerns?
The first thing that I thought about was, because I had retired and I gained that experience outside of the Albuquerque Police Department, and at the tribal agency I was at, a lot of our cases did go federal. And I had really learned about Brady Giglio. We had really had to work with our detectives or any officers prosecuting any cases that were going to go in the federal system. I had become very familiar and I knew the importance of this, but I also recognized that it's a good way for us to self-assess and to monitor ourselves and to know what obstacles officers may have in testimony in the future. So for me, it was a win-win. I think it did help that, if you truly believe in community policing, you have to work with your prosecutor. That is one of the community partners that is part of the criminal justice system. Myself and DA Torres had a good relationship. We were open with one another. Sometimes we probably frustrate each other, but at the end of the day, we always remember that we have to do the things we do for the better good of the community. So when he approached with this, I like the concept. I think it is a good way to be transparent with the community and everybody involved. And one of the things that I've learned over the course of the last 18 months is transparency is the key to keeping communities happy with the police department and not feeling that things are being hidden. And as we look at these national narratives about the reform of police departments, this and transparency go hand in hand with being honest with the community. So I was accepting of it. We liked it. There were some questions that we had to work through. It wasn't a perfect product right off the bat. The union brought some of their concerns up, but we were able to work through some of the questionings or the way they were worded, and we're able to get to a place where we're fine and working well with one another to provide this information. Our union, because they were talked to beforehand, they seem fine with it. Like I said, there was some questions, and our officers are learning that it's just part of everyday business. Recently, we did have a case come back where we have somebody who fell on this list federally, and what it's done for me is be able to figure out where I'm going to place this officer, because I think it's important that we have officers who are able to testify in some of the high-profile cases they're involved in. And one way I've sold this to officers is I talk to them about the fact that I'd rather know beforehand and put an officer somewhere where they're successful than, Lord forbid, we have an officer who's killed and the testifying officer is unable to testify because of their history.
That does sound like a compelling way to convince your officers that it's not a terrible policy and it actually might help the police department long-term. Ross, I wanted to turn to you. So, at the Control Center, you've done a lot of seminal event reviews. If you could explain for those in the audience who don't know what those are, just describe what they are, please. And then, whether you've seen the lack of a Giglio policy or some kind of police misconduct tracking mechanism contribute some of the problems that you've observed in the criminal system.
Sure, and thanks very much for the invitation. It's a pleasure to be here and in what is a very important conversation. As you mentioned, what we do one of the things we do at the Quattrone Center is what we call a sentinel event review, or it's also known as a root cause analysis. And what that process entails is, in any particular jurisdiction, a group of stakeholders are convened to identify cases or a particular issue that is a never event, something that shouldn't happen, something that's produced by the criminal justice system that the criminal justice system doesn't intend. And those stakeholders then come together to develop a consensus approach to identifying what the contributing factors were, and then coming up with recommendations and things they can implement in policy. What makes it unique is number one, getting the stakeholders together to agree on what never events are, because that's an interesting conversation in and of itself in terms of what kinds of outputs of the criminal justice system are the things that can really benefit from that kind of analysis. The easy one to conceptualize are the wrongful convictions, the idea of somebody that is determined to be factually innocent, who's been convicted of a crime that they didn't commit. And many of the sentinel event reviews are centered around those types of incidents. But it can also be any number of other characteristics or things that happen in the criminal justice system that are not what the system's designed to accomplish. And where we have seen, obviously, any given situation or case that we might be examining with a group of stakeholders is going to have its own characteristics, and they're obviously very fact dependent. But one of the key features of the sentinel event review is to take a systems approach and think about all the stakeholders and all the different actors in that system working together in order to accomplish the goals of that system. Unfortunately, because it is an adversarial system by nature, the normal operation of the system is not the best environment to try and identify and resolve issues as they come up. So by taking these situations out of that adversarial context and looking at them in what we would call a blame-free methodology, the issue is not to point fingers at everyone, it's just to say we don't want this outcome. What can we do to prevent it? And in doing that and looking at the roles that each individual stakeholder plays, whether it's the police department or the prosecutors, institutional defense, the courts, one of the common features that is identified as contributing factor in many of these errors is a lack of communication or an information void that happens between those stakeholder agencies. A big one that jumps out in a lot of cases is the disconnect between the police, law enforcement agencies, and the district attorney's office. That can be, things as seemingly benign as just having different document retention systems and evidence management systems that don't communicate with each other, so information gets lost, or other situations where without, before the advent of some of the Brady list and the things that DA Torres is talking about doing, another category of information that fell into that void was disciplinary records and other information from the police department that could have bearing on the criminal cases. I think one of the learnings from that process, and Chief Medina hinted at that, is our experience has largely been that when the stakeholders are working these things out and talking about them as factors, most of them are pretty readily agree that having that information as available and as available to everyone as soon as possible is a huge benefit, because there's always there's an instinct sometimes that I think in our historic approach to criminal justice, where each stakeholder sort of has a bit of a defensive posture relative to the other stakeholders. And that's understandable because of that adversarial nature of the system. But one of the things that we find when we do create mechanisms for greater transparency and for that information to pass through those levels and get to the prosecutor, from the police to the prosecutor, and then to defense counsel, is it also puts the prosecutor in a position to where not only can they more adequately assess their cases completely and understand police officer witnesses in the same way they might a civilian witness, it also allows them to understand that not everything that may cause an officer to get onto that list or be something that's flagged is necessarily germane to a particular case or what an officer's role is in the case. And so it also gives the prosecutors the ability to basically, stand up for those officers or sort of create and be able to separate those things that actually are going to be potentially material in a case and which are not. And that's where, disclosure and transparency always benefits each level of that process as the cases move through. And the real questions can be resolved in when it comes time to talk about admissibility of the evidence. And that's one of the things that I think gets lost, is that each level makes its own determinations about what they think is material for any particular judgment. And that discretion at all those different levels is often where we see a lot of these errors come up, because the way a police, somebody in the police department looks at something, the way a prosecutor looks at something, the way a defense counsel looks at something may be completely different. But if they all have the same information, then in the transparency of the courtroom, issues about whether or not it's admissible, and if so, for what purpose, and whether it has bearing on that particular case, can be fully explored.
So is what you're saying, Ross, that it's better essentially to err on the side of transparency rather than evaluating, for instance, as a prosecutor, whether or not something is material, and to sort of just litigate that later as to whether or not it's admissible? I mean, I know we're getting into a bunch of legal technicalities, but I think, since most of the people who are watching are prosecutors, is that sort of what your work at the Patron Center and then also your experience as a defense attorney has sort of taught you over time?
Well, it's something to avoid. Chief Medina said it best. It's just better to know in advance, because that way you can discuss what it actually means. And some of these things may be quite material and could, in fact, create a real issue for the prosecution of a case. Some of them may not. But if you don't, if the individual actors in the system don't have access to the information,
right,
you run the risk. You're creating different levels of risk in those downstream actors. And if the information doesn't get to the prosecutors, they may be doing something unwittingly where they've now created a Brady situation for themselves. And if that information doesn't get to the defense attorney, you can have a situation where after the fact, litigation can ensue over information that, had it been disclosed in the first instance, may or may not have had a material impact on the case. But by resolving it ahead of time, it prevents those issues from affecting the case later. And you mentioned, in terms of the defense attorney angle, one of the things, an interesting comment I would have is, I really never saw anything about police officer misconduct when I was at the Defenders in Philadelphia, because there just really wasn't anything being disclosed. What we see later is information surfaces, and then we're sort of looking back at all of these different cases, and what could have been something to handle one case now is something that we're reviewing in a large set of cases. And when we did get information, defense lawyers talk to each other. They, an institutional defender has a lot of resources. For the prosecutor, I'm sure DA Torres would agree, a defense attorney walking into trial ready to deal with a piece of information that they weren't aware existed is not a situation that a prosecutor is going to want to be in. And that, again, is where it gives everyone the opportunity to assess the substantive value of that material in order to make sure that the cases are being sort of accurately treated at each one of those stages.
Right. Yeah. We in the action guide, one of the reasons we cite, of course, is transparency and prosecutors being able to fulfill their ethical obligations, but also at a bare minimum, strategically, prosecutors don't want to get ambushed by information that maybe the defense has, because defense organizations and other community organizations are now compiling this information themselves. And so strategically, prosecutors, they don't want to be surprised at trial by information about their own witnesses. So I was going to ask DA Torres something at the end, but we have a Q&A that it's already come up. So I'll just ask the question now, which is on your website, DA Torres, you have the office, I think you have the officer's name and a sort of a general letter saying that there's information that needs to be disclosed, but the actual nature of the impeachment information is not in the letter, so it's not on your website. So the question is, why is that? And this person says, on the one hand, not having anything almost maybe looks worse for an officer where the disclosure is minor because there's no explanation. On the other hand, maybe there's some privacy concerns. And so just wondering what the thought process was in making it public, but not 100% public.
Right, and so one of the things that I probably should have elaborated on in terms of the full process is that when this disclosure is made, oftentimes we will file a motion with the court asking the court to keep the information under seal until the court has an opportunity to evaluate it and then allow the court to unseal the details or allow the parties to publicly discuss the details. And it has, frankly, everything to do with the privacy protections and the personnel protections that are currently afforded to police officers in New Mexico and officers, frankly, around the country. And interestingly, I know that there are some jurisdictions where I've spoken with district attorneys who want to make these types of disclosures, but what they say is, I'm prohibited from disclosing the information. So to a certain extent, what this does is it publicizes and publishes our office's determination about whether or not we believe Brady and Giglio material exists and should be disclosed to the defense and to the court. And then we leave it to the court to make a determination about whether the parties can then elaborate. And, there are some liability issues that prosecutors need to be aware of when they talk about this. And we came down on the side of essentially publicizing our analysis of what the underlying information is, and then leaving it to the court to basically enable the parties to publicly discuss them either in pretrial motions or at trial themselves. That provides an extra layer of protection, both for our Brady Giglio panel, but also for our prosecutors, because there may be instances where we believe that this is something that should be disclosed, and perhaps a police officer and his representative or his attorney disagrees with that. We have taken the position in the implementation of this policy that we are not going to move to limit the right of an officer to make that argument to the court. Now, usually that argument would be made in camera to sort of protect those privacy interests that the officer may have. But we have tried to strike the right balance to give officers the ability to intervene in the action for the limited purposes of contesting. This is something that shouldn't necessarily be disclosed. And the names of the officers and the conduct that is listed there, or I guess the conduct isn't listed, but there is a range of conduct that is implicated in the disclosure of that list that runs the gamut from real misconduct, very serious allegations and findings in police records, to technical findings of time card fraud, for example. Or we even have an officer there who had a conviction that falls within our time period before he became a police officer, but it technically counts as a crime of dishonesty. By all accounts, this is a good officer, and an officer that we would argue is somebody who should be allowed to testify in court. And we would also make the argument that the conviction that officer had prior to joining the police department is not relevant to his testimony, but that doesn't have any bearing on whether or not I'm obligated to make a disclosure. And so we wanted to err on the side of accountability, but also balance that to a certain extent with the rights of officers to protect the underlying information, and then leave it to the court whenever there's some question about what should be disclosed in terms of the underlying records.
Thank you. And just a quick follow-up question, because we have another question for you from the Q&A, which is, you're not mandated to have this kind of policy by statute or anything. This was just a decision that you made.
That's right. There are no mandates. There's no legislative mandate of any kind. I will say this: the local sheriff's department, unlike Chief Medina, was not cooperative when this policy was first announced, and he publicly said he would not comply with the policy. We got into a bit of a standoff. He ultimately came to the conclusion that he was forced to comply with the policy and turn over the records. But we did introduce legislation in the Capitol that would require police officers to answer any Brady or Giglio inquiries of any kind by local prosecutors, and make that a condition of continued certification as law enforcement officers. And that's something that may continue to be pursued at the state level if we have the adoption of this policy by outlying jurisdictions and police leaders who are unwilling to participate.
Chief Medina, I guess this question could go to you too, DA Torres, based on what you just said about your sheriff. But originally this question was going to be for just Chief Medina, which is, what would you say, Chief, to a prosecutor, an elected prosecutor who wants to be able to obtain information from their local police department about disciplinary history, but they perhaps don't have as strong of a relationship as you and DA Torres obviously do? Oh, Chief Medina, I think you're muted.
The saying of 2021, I think you're muted. The one thing I would say to a prosecutor is build that relationship. Like I said, community policing chiefs need to remember that it's all about partnerships. We're all on the same team. And I've been around this department 26 years, and I remember times when chiefs and DAs could not speak to one another. And just think about that. We're out here for the good of the people. We're out here trying to do a job for the community, yet the two biggest pieces of the puzzle to prosecute a case, the heads of those agencies can't talk with one another. So you have to develop a relationship, and it may not be the best idea to go in and start the relationship with, I need this, relationship build. We do it every day. One thing that the DA did do that really helped the relationship building is he came to me and he said, hey, look, I know there's some struggles your investigations are having. Let's work through this together. And we've really teamed up to help each other work better and to improve both of our processes. So I think approaching the chief in a way that you're showing that you're trying to assist them in some ways and you're trying to help them become better, offering training, offering to do debriefs on cases where your department's been embarrassed, quite frankly, in the media, because we've had several of those in Albuquerque, are key. But also to the chiefs out there, you got to recognize that sometimes you got to take with a grain of salt that your agency isn't doing the best job it can, and that you need to make changes from within. And somebody trying to help you identify those is truly helping you become a better agency.
Thank you. Ross, I was going to ask, as someone who does these Sentinel event reviews, but also as a former defense attorney, what forms of police misconduct do you think prosecutors should be tracking? I mean, dishonesty is an obvious one, or if they have, criminal convictions in their history, that's an obvious one. But what other ones do you think might be less obvious that prosecutors should incorporate in their GLEO policies?
Well, that's a great question, and one that I think presents some of the more complex problems in this discussion. As you mentioned, the things that involve dishonesty, that's low-hanging fruit because we all understand, what the relevance of that is. One of the reasons why I would suggest, and I think what we've seen in Sentinel event reviews would corroborate this, that it's better to err on a side of over-inclusion in terms of the information that's available to the district attorney, the prosecutors. And I want to say here too that I think that there's a reasonable differentiation between what should be made available to prosecutors and defense attorneys versus what should be publicly available. I think reasonable people can disagree about those two different categories of information. But in terms of what goes to those primary stakeholders that follows the criminal case, to the prosecutors and the defense lawyers, anything that involves, handling of evidence, which could come down to things that initially look like some kind of violation of an administrative rule or some other, internal policy at the police department, or anything that shows, we talked about like time card fraud, those kinds of issues that come up. Again, the questions are really about admissibility and what the impact is, not so much whether it should be included. And the reason why it's hard to answer the question, and why I think having a more sort of over-inclusive idea about what goes on there, so at least for the stakeholders, is that, as I mentioned, every stakeholder is going to look at this questions differently. And I used a word earlier, which is a very heavy word in this world, which is materiality, right? And we're talking about materiality as it relates to Brady disclosures, and I won't go off on a tangent about what the legal conundrums around materiality. But one of the things that we have seen time and time again in these cases is where information that either does change hands or doesn't change hands, but different people are making good faith assessments of it, and they think, I don't have to put this on the list. I don't have to disclose this. This doesn't fall within Brady. It's not exculpatory or it's not material. And so they're making these judgments that in their particular role seem like, appropriate and accurate judgments. But then you give that same, what a police administrator, a police officer says about a particular document, and then what the interpretations for a prosecutor could be completely different. And then when it gets in the hands of a defense lawyer, their views could be completely different. And part of that is that each person in that process has access to a different universe of facts. And so they're applying all that information to interpret what they're looking at. And so this is, I know, a longer answer than probably what the question seems to demand, but I would say that anything that involves, those violations of rules or policies, we have to think about that broadly, because one other aspect of that is the way things are characterized from a policy perspective can be very different once you are looking at the underlying facts. And so it's hard to put them into bins and say, well, we're just going to have these certain types of violations that are going to go into the list, because we have these others where, okay, well, this was just a complaint that was sustained that was based on, improper comments to a civilian, on the street. Well, that doesn't matter. That really doesn't go in there. Well, then you might look at the facts of that, and maybe that shows some type of inappropriate bias or something related to use of force or something else. And we've seen that in what's come out now as we're getting more information about police, civilian complaints around police, where you see this disconnect between how they're characterized from an administrative standpoint and what the facts seem to be telling you. And so because of that, I think we have to be very cautious and really think again about getting as much transparency as possible. And then to the extent there is a fight, that becomes about admissibility and relevance, but not about whether or not the information should be assessed. Every stakeholder needs to understand and acknowledge that the other people that are part of that process, the other important actors, may have information or an understanding or experience that gives them a completely different, but still good faith and accurate interpretation of what that information means in the context of a case.
Thank you, Ross. DA Torres, I was going to ask you, but I want to make sure you're still there. There you go, sunny Albuquerque. I think a lot of people here are probably wondering, for those who don't have some kind of list or database, what work is required to create a policy? We at the IEP, we put the appendix up that has all the other offices that we interviewed, their written policies, so you don't have to reinvent the wheel. But DA Torres is someone who has gone through the process. What recommendation do you have for the elected DAs watching or management level prosecutors who want to create a database? How did you sort of decide what your policy was going to look like, and how would you advise another office that's looking to do something similar?
The first thing is you have to set out some core principles, and one of the, for me, and one of the most important, which Ross just mentioned, is this idea of erring on the side of disclosure. And then if you have to have a fight again about relevance and admissibility and things like that, that's fine. But what are you trying to accomplish? And what I set out to accomplish is fundamentally a greater level of trust in the outcomes of the criminal cases that we presented in court. And I think what informed that is this recurring notion that years after the fact, oftentimes there would be some disclosure about a police officer who had very serious misconduct in their history, and that there was some presumption that prosecutors knew it and prosecutors should be held accountable for that, either because they failed to do their job or because they were complicit in some way, because they knew about it and intentionally put an officer on the stand without making the proper disclosures. So I viewed it as, number one, as a way of restoring public trust, but also as a way of frankly protecting the professional reputation and integrity of my office and of individual prosecutors. I have a very big office with a wide range of experience and skills. And so I wanted to make sure that I built a system where I could maximize the experience and skill set of lots of different prosecutors in my office, and bring them to bear on making these kinds of decisions about disclosure. So that's why I think the Brady panel is an established panel inside the office is key. And then a clear set of parameters of what type of information you're going to ask. And then what we tried to do is link the types of information that we were asking for as closely as possible to the personnel policies and procedures of the department that we were dealing with, so that there wouldn't be any ambiguity about what we were asking for. And interestingly, I think what we have found to be an emerging area in all of this is the use of police officers' social media accounts off duty and what they say, and whether or not that is demonstrating some sort of bias or prejudice against a protected class. Not every police department or police agency has established good social media policies about its use and disclosure. Fortunately, the Albuquerque Police Department does, and our other agencies do. But that was an area where there is probably more of a judgment call than anywhere else. In other words, if there's a finding that an officer lied on a report, or an officer made a derogatory comment to a member of the public while on duty, and there's an official finding, those are really relatively straightforward disclosures to make. What is a more difficult disclosure to make is whether or not an officer's social media commentary not necessarily crosses some boundary of what we would think to be a norm that shouldn't be crossed, but whether or not it violates the agency's policy. And we were very fortunate to have in the Albuquerque Police Department a pretty solid social media policy, but there was a lot of negotiation with the union there. So I would tell people to be very careful about that and err on the side of disclosure, not only as a means to safeguarding public trust, but also to protect your prosecutors, because you don't want them to end up, months or years down the line being accused of being involved in some way, knowingly failing to disclose information. But you also want to make sure that you can protect cases. I mean, a lot of times we would end up in situations where we would get ambushed with an officer's social media commentary. And when we went back and looked at the case, we actually figured out some of the officers that we put on the witness list and we called to testify, we didn't really need those officers to make the case. But suddenly the trial, rather than being about crime and guilt and innocence, it becomes about the potential for prejudice of a police officer who is not central to the case. So another key component to this is it's a way to safeguard those prosecutions and from a tactical level, make decisions about eliminating those, the ability of those officers to derail important criminal cases, because if we could avoid putting them on the stand, then we avoid having the criminal process become about something other than guilt or innocence.
From what we've learned from the different DAs who we've spoken to, some of this is you put out a policy, you implement it, and then you sometimes have to make adjustments. Were there any adjustments you had to make? I mean, it sounds like with social media, you had to sort of maybe change the questionnaire a little bit, but were there any other hiccups along the way or things you had to revise once you implemented it?
Well, we had to be a little more flexible. So originally we wanted the agents and the officers themselves to fill out the questionnaires. Frankly, for logistical reasons, we would just email you the questionnaire and you would fill it out. We have agencies that are willing to do that, and we have other agencies, for whatever reason, they've received guidance that they won't fill it out in writing. So they'll only answer the questions if we ask the questions while the questionnaire is open in front of an ADA and the ADA is on the phone with the officer. We could have drawn a hard line in the sand and said, no, you will physically fill this out, but that's an example of something that we've had to sort of modify, and I'm sure we'll modify again. The other thing is an ongoing discussion about to what extent individual officers should have the right to appeal to our office to have themselves removed from the list and from public disclosure. That's an area where I can predict that there's going to be disclosures that are made in the future where an officer and his or her attorney strongly disagrees with the public disclosure, and they're going to want clear guidance on what it would take to remove them from our public list. And we still have a lot of work to do in that regard. But I don't think these are questions that you're always going to confront as an elected DA. And I wouldn't say that because you can't answer every aspect of the unforeseen side of a policy's implementation, just because you can't answer that, should not be a reason you shouldn't embark on the journey to sort of bringing this policy into being. I will say also from a logistical standpoint, adding in the questionnaire is a very difficult and time-consuming thing. So some will fall back just on agency letters. We viewed it as a way to give the officer an opportunity to potentially provide more context and give their side, and provide, frankly, an opportunity for self-disclosure, which we then think will be relevant to a court when they have to consider whether or not they want to make the underlying information publicly available or not.
Thank you, Chief Medina. We have two sort of related questions for you that came in through the chat. One of them was, have you seen any impact on police behavior? Oh, I didn't know that you got into your car. I'm sorry. Have you seen any impact? Have you seen any impact on behavior from officers as a result of this policy? And then has there been any negative impact on your police force as a result of the disclosures being made public?
No, we haven't seen any impact in officers' behavior. And I think that stems back to, we implemented a body cam program years ago. And I think that when we put officers on video, it automatically corrected behavior. When somebody's being recorded, they tend to act differently. So I think a lot of the conduct issues were addressed with the body cams. And when somebody gets in one of these situations where they're doing something, it's clearly misconduct that is against policy, and I think they're going to go through with it either way. And in terms of impact on the department, at first there was some grumbling from officers about having to fill out the forms. We had to work through, and we had to figure out, like, some of our policies, misleading an investigation as opposed to lying. There are some things we had to work out internally as where they fell within the questionnaire, or what was clearly the intent of a policy. We worked also with, like DA Torres mentioned, we had a period of time when somebody could be hired and them committing a crime, and we had to work through that because we potentially could and did hire individuals who would fall into Brady immediately upon being hired, but yet they met our hiring guidelines. So there hasn't been a big impact, but we have had to work through a few issues along the way.
Thank you. And Ross, we have a question, another question in the chat, which is your view as to whether, so we're only talking about, I think, disciplinary findings. So whether only substantiated allegations should be disclosed, or all allegations, even if they are, pending or say even disproven, or, if I think officers are often labeled as exonerated of a disciplinary investigation.
Yeah, that's a tough one, because I think obviously, while, as I mentioned, I think there are a lot of benefits to being as, overly inclusive as possible. I do think it can be pretty tricky when you're getting into that level of, sort of procedural posture of where these basic infractions go. I do think, at least with respect to getting that information to the prosecutor, it's essential for them to know what potential issues and ramifications there are related to that particular officer. And I think the reason why that is of particular importance, and I think it would still probably go in the column, in my view, of making that information known, passing that information along, even if there is not a final resolution. If it is something that were at final could be significant. We've seen cases, there have been plenty of situations that have arisen even in Philadelphia where we are, after the development of the conviction integrity unit here, as they started to go back and look at cases, you've seen a number of situations where There have been officers who are in various states of internal affair review or some other issue for administrative problems. They were continuing to work regularly as a police officer and continuing to be involved in cases. And then as something, as something concrete ultimately comes to light at some point downstream, it creates a real logistical problem to go back and try and sort out what was happening when and what they knew and whether or not there was sort of material information about that officer that was relevant. And a lot of that goes towards the conduct. It's obviously in terms of, the finding itself, that's something that's important because it's been through that process. But a prosecutor or a defense lawyer may look at that information and the allegations of the conduct, and that conduct itself, if it's demonstrable in some other way, there could be statements about that conduct or videos about that conduct. So the finding itself, or sort of getting to that conclusion in the administrative or disciplinary process, should not be a sort of bright line rate limiter. But I do not envy those like DA Torres that have to look at that and make those kinds of decisions. But I again would come back to that information. It's best to get that information and make it available so that its potential impact can be assessed. And again, from a prosecutor standpoint, certain information, and I mentioned Philadelphia, but there have been some very particular cases in the last couple of years where there was a lot of conduct sort of by particular officers that had the district attorney's office known about certain pending processes or known about the conduct. Number one, they could potentially investigate the officer for issues that are germane to their office, in case they involve a commission of a crime. But number two, also investigate in a more holistic way those cases or the unit or whatever might be involved, so that they're able to better do their job and and better prosecute those cases and try and identify those things before they become problems. So again, I fall back to the more disclosure is better. There are plenty of places in the process where you can have your disagreements about whether and how it should be used. But I think it's absolutely vital that the prosecutor's office has access to that information so that they're able to be aware and track that process as it's going through, because it could have a lot of implications for many other cases. And I think that the most prosecutors would rather be able to assess that on the front end and dealing with everything retroactively.
DA Torres, does your office disclose pending or unsubstantiated claims of misconduct?
No, we are very much in a world where we are relying on the process inside the agencies to identify, and I agree with Ross. He makes a very good point about whether or not something is pending investigation but has not reached resolution. And I will tell you that more than anything else, it's not so much a matter of policy as a matter of logistics. For example, we have in a typical year somewhere in the order of 20 to 25,000 referrals that come to my office. And so, almost every one of those has an officer attached, and usually 2 or 3. So you've got tens of thousands of potential questionnaires that you may be asking people to fill out. We made a determination early on that we were going to ask a questionnaire, and then within the next 6 months, we would ask the officer, you filled out the questionnaire January 1st. It's now March 15th. Has anything between January 1st and March 15th, now that you brought case number 2, changed from what you said? And we'll show you your answers on the first questionnaire, yes or no. And if they certify that nothing has changed, we won't make them fill out a new questionnaire. But that was a judgment call based on what we thought was our ability to keep up with the logistics, because anything longer than 6 months seemed like too long a period. Anything shorter was going to be a huge burden on these officers, because we have certain officers, DWI officers, for example, that will bring multiple cases a week, and they would end up spending all their time filling out questionnaires in my office and not enforcing, DWI. So we have to make a lot of adjustments to the ideal just based on the limitations of our logistical capabilities, which is part of the reason that I always urge prosecutors to think simultaneously about making the necessary investments in their information and technology infrastructure, because to the extent you can set up automated processes and systems to do this kind of work, you're going to relieve the workload and the burden on both prosecutors and police officers so that they can continue to do their core functions, because there certainly haven't been any new appropriations made by the legislature for our office to implement the policy. But almost more than developing a policy, I would say our policy was not that difficult to come up with. The logistical mapping and the process mapping that went along with it was far more difficult, about when to send a letter, what to do with it, how often to send a follow-up letter, how much time it would take, and then how to push out that information to our prosecutors, right, on an automated basis, because we could have a police officer fill out a questionnaire in January, and then we hire a new prosecutor in February, and they're not automatically, right? So we have to disseminate not only the information to the public on the website, but internally inside the office. And so we're coming up with a system that would automatically flag anytime an officer's on this list. A flag would just pop up in the case management system notifying this attorney, hey, this person is on this list. And it would seem simple enough just to tell your prosecutors to look at our own website to look at the names, but they live in a world where they oftentimes don't have time, or maybe they looked at it last Monday and the name got added on Wednesday, right? And so you have to have an automated technology component to this that really distributes the information in real time, but in ways that don't completely bog down the system.
Right. It seems like one of the biggest challenges is how you get that refresh amount of information from the police, whether you're doing it through a questionnaire or I think a lot of offices just have a system where the police department every few weeks or months sends a new batch of disciplinary records, but then having to reconcile the new information with what you already have. I think, it's just a lot of logistics and IT work. I promised our panelists that this would not take more than an hour, and I am 2 minutes over my promise. So unfortunately, even though we still have questions and Q&A, I'm sorry, I do have to cut off the conversation and let our panelists go. But I wanted to thank all of you for participating and for being here to talk about this really important issue of, prosecutorial ethics and police accountability and transparency with the public. And of course, thank you to our audience for being here today, and the IIP team for helping us put this together. So thank you everybody for being here. And of course, email us if you have any questions at all about this topic or the action guide that the IIP put out last month. So have a good day, everybody.
Thank you.
Thank you.
Thank you.